Good afternoon, everyone. Welcome to this very special event at the Council on East Asian Studies. My name is Jing Su, the chair of the council. And this afternoon, we welcome you to our inaugural lecture to celebrate a very special, the Hong Kong Friends of Yale Fund. Today, as our very honorable guest, I have the distinct pleasure of introducing to you Margaret Ang. Margaret Ang is a barrister in private practice with a long record in public service. And it is quite rare, I think, that as many public figures as we do coming through the Macmillan Center, very few has had such a non-conformist trajectory as Ms. Ang. Ms. Ang actually received a BA, and this delights me the most since I'm a literature person. She received her BA in comparative literature and an MA and PhD in philosophy before she then somehow bumped onto this path of becoming one of the most important outspoken voices in contemporary politics in Hong Kong. She served on the Legislative Council of Hong Kong for 16 years before stepping down September 2012. And during this time, she was the chairman of the Panel on Administration of Justice and Legal Services. She was deputy chairman of the Committee on Rules of Procedure for 15 years. From 2001 to 2012, she was a member of the Legislative Council Commission, which is a statutory body established for the management of the administrative support for the operation of the council. And during this time, she participated in 155 bills committees, 51 for which she was the chairman. Her particular areas of interest were international justice, especially touching on the independence of the judiciary, the rule of law, human rights, and constitutional development. So since she stepped down, Margaret Ang has continued her outspokenness and participation in public life. She has had numerous publications, which is nothing new since 1979. She has been writing for English language newspapers in Hong Kong Standard and the South China Morning Post. She joined the iconic Chinese language newspaper Mingbao Daily News in 1986, where she met Jin Yong, a subject of her thesis. She participated in the modernization of the editorial policy of the newspaper to expand its coverage on political news. And in 1990, she returned to her legal career, but continued to publish a regular column and articles in both English and Chinese. And in very recent months, Margaret Ang, of course, has been an on-ground observer of the umbrella movement. And it's with distinct pleasure, tremendous honor, that I hope you will join me in welcoming our speaker for this afternoon, the inaugural speaker, Margaret Ang.
Thank you, Madam Chair. It is a great pleasure to be back in Yale after so many years, and it's really delightful to see so many old friends and young faces. Ladies and gentlemen, Hong Kong was returned to China in 1997 on the basis of the Sino-British Joint Declaration signed between China and Britain in May 1985 after 2 years of negotiation. Under the joint declaration, Britain promised to restore Hong Kong to China on the 1st of July 1997, and China promised that after the handover, it will follow a 12-point basic policy on Hong Kong, whereby Hong Kong will enjoy a high degree of autonomy, with Hong Kong people governing Hong Kong under the one country, two systems principle for 50 years unchanged. The 12-point basic policy was set out in detail in the body of the joint declaration and further elaborated in an annex. Hong Kong was to be vested with executive, legislative, and independent judicial power. Its system of law will remain basically unchanged. Its social and economic systems will remain unchanged. And the way of life of Hong Kong inhabitants will remain unchanged. Their rights and freedoms will be protected by law. Most important of all, the joint declaration, together with its annexes, were presented to Hong Kong and the world as a solemn international treaty between sovereign states and binding on the parties. This was vital because China was a socialist state, still is, under the Chinese Communist Party. Civil liberties were subject to harsh repression. Hong Kong was under colonial administration, but it enjoyed the rule of law. People were generally left alone to live their own lives. The rule of law and a clean, reasonably transparent government were basic conditions which enabled the international community to use Hong Kong as a safe business and financial center. Without the strongest legal and political guarantee for its future, handing Hong Kong back to China would have been an act of unmitigated irresponsibility of Great Britain. On the basis of China and Britain's repeated assurance that the promises in the joint declaration were binding as an international treaty under the legitimate scrutiny of the community of nations, Hong Kong people accepted the reversion of Chinese sovereignty. In 1990, as part performance of the terms of the joint declaration and to give confidence to Hong Kong people, China promulgated the basic law of the Hong Kong SAR under Article 31 of the Chinese Constitution, and so it is the national law of China and a mini constitution of the Hong Kong SAR, setting out Hong Kong's high degree of autonomy under one country, two systems principle. With these instruments, Hong Kong has to build its own future. The two central tasks are preserving the rule of law and developing a democratic system of government, without which the rule of law cannot long prevail under Chinese sovereignty. At the 30th anniversary of the joint declaration, it is now time to review how well has Hong Kong fared in these two central tasks and take a hard look at what is really happening in Hong Kong. To the casual visitor, everything seems fine. But to a great many Hong Kong people who live and work there, it is another story. The sudden breakout of the umbrella movement or revolution last September dramatically exposed the depth of accumulated frustration. The crisis was precipitated by the demand for democracy, but it also brought into sharp focus questions of the rule of law. The rule of law and democracy present serious problems to Hong Kong's future, but not just Hong Kong's future. What will happen to Hong Kong cannot but reflect the way China behaves, and how China deals with Hong Kong cannot but review the kind of politics that still dominates China. If the international community felt it had a stake in the joint declaration 30 years ago, it was because Hong Kong's fate under China mattered. That remains true today. China's greater economic power today only makes it more pressing to consider the prospect of China developing some kind of rule of law and democratic accountability. A fundamental concept of the rule of law is that the government is under the law. But in China, the party operates above the law, and judges must follow the party's guidance. Would China tolerate an independent judiciary in Hong Kong, which does not hesitate to overrule the government? The SAR government had worked hard to point out to the international community the many assuring provisions in the basic law. For example, the law previously enforced in Hong Kong shall be maintained, Article 8. National laws shall not be applied in Hong Kong, Article 18. The Hong Kong SAR shall be vested with independent judicial power, including that of final adjudication, Article 19. Judges shall be chosen on the basis of their judicial and professional qualities and may be recruited from other common law jurisdictions, Article 92, and so on. They sound astonishingly liberal and impressive, but how strong their protection is can only be tested against reality. The first challenge is the real effect of Article 158. Article 158 says, in effect, that the power of interpretation of the Basic Law is vested in the Standing Committee of the NPC. The courts of Hong Kong are authorized to interpret Basic Law in adjudicating cases, except that before making a final decision which is not appealable, if it turns on a provision which concerns matters within the responsibility of the Central People's Government or the relationship between the central government and Hong Kong, then the courts has to refer the question to the NPC Standing Committee for interpretation. Would this article be used to unravel all the promises given in the rest of the Basic Law? The test came sooner than expected. In January 1999, in a case involving thousands of children of Hong Kong permanent residents born outside Hong Kong who have been separated from their parents because of the exit permit system in China, the Court of Final Appeal gave its judgment upholding their right of abode in Hong Kong under Article 24 of the Basic Law. The judgment of the Chief Justice, Andrew Lee, was harshly criticized by legal experts in Beijing. In June 1999, the NPC Standing Committee issued an interpretation under Article 158, overturning the court's judgment in spite of the strong opposition of the legal profession in Hong Kong because of the devastating effect on the rule of law. All but a few of the children who were named in the litigation lost their right of abode declared by the court. The legal profession protested in a silent march. You see in the picture the Court of Final Appeal. The interpretation was arguably against the Basic Law. But if so, the power to impeach it lies only with the NPC Standing Committee, the author of the interpretation. The controversy shook confidence in Hong Kong and the international community. SAR government officials went on a damage limitation exercise to assure foreign governments that an interpretation would be an unusual event. On the other hand, they also insisted that it was consistent with the rule of law because the power of interpretation is already stated in the Basic Law itself. 6 months later, in a judgment in another right of abode case, the Court of Final Appeal acknowledged the NPC's freestanding power of interpretation, and that an interpretation resulting from the exercise of that power will be binding on Hong Kong courts. From then on, the shadow of NPC interpretation hanged over the rule of law in Hong Kong. The second interpretation came in April 2004 at the NPC Standing Committee's own initiative, altering the steps to be taken to introduce political reform in Hong Kong, which we'll discuss further later. The third interpretation came in 2005. The fourth interpretation was issued in 2011. It was also the first time an interpretation was given at the request of the Court of Final Appeal in what is known as the Congo case. The immediate effect of interpretations is that it renders the understanding of the Basic Law uncertain, as well as the rules by which the legal meaning of any provision is ascertained, even when it concerns only Hong Kong's internal affairs. This affects the predictability of the law. While judges may insist that the courts will interpret the law only on legal principles and not political considerations, the public may well ask, what is the point of seeking judicial adjudication if it is China that decides at the end of the day on political grounds? This fear is reinforced by the government, which does not hesitate to threaten to go to the NPC for an interpretation if the court is minded not to accept the government's view of the law. The Hong Kong courts had openly referred to these threats and the court's rejection of these threats in their judgments, but political pressure continues to increase. The situation has now developed that in a case pitching the individual's rights and freedoms against executive power, the public's concern has come to focus on whether the government will ask the court to refer the question to the NPC for interpretation and whether the courts will be able to resist the pressure. This has become a test of judicial independence and the rule of law. One notable case is, as I mentioned earlier, the Congo case in 2011. The issue before the Court of Final Appeal was whether, after 1st of July 1997, the doctrine of state immunity, which applied in Hong Kong, was restrictive or absolute. That is, whether immunity extends to commercial activities of state entities. But of much greater public concern was whether, before giving its final decision, the court should refer the question to the NPC for interpretation of Article 19 of the Basic Law on Act of State. The court, by a 3-2 majority, decided on referral, giving as its provisional view that absolute immunity, that is, according to China's policy, applied. The case was highly controversial, both on the issue of state immunity and on referral. In his dissenting judgment, Judge Bukhari said this: "It has always been known that the day would come when the court has to give a decision on judicial independence. That day has come. Judicial independence is not to be found in what the courts merely say. It is to be found in what the court actually do. In other words, it is to be found in what the court decides." These remarks were themselves controversial. Whether one agrees or disagrees with them, there is no denying that they are evidence of the community's deep unease about the court's will and power to defend the rule of law in deeply political cases or cases where the Central People's Government has an interest. Interpretation came into play in a different way in a case in 2014 concerning foreign domestic helpers. Numerous Hong Kong families rely on foreign domestic helpers. Under immigration policy, a foreign domestic helper is not qualified to apply for permanent resident status however long they stayed. Hong Kong law defines their stay as not within the meaning of ordinary residence. The issue to be tried is whether this lawfully precludes her from ever qualifying as a permanent resident under Article 24 of the Basic Law. But people were far more concerned about whether the government would take this opportunity to seek an interpretation from the NPC on other parts of Article 24 so as to overrule a judgment of the Court of Final Appeal made 13 years ago, declaring the right of abode of Chinese nationals born in Hong Kong. A political campaign was launched to fan the fear of the community that migrant workers would flood into Hong Kong if the government should lose the case. In the event, the court decided against the foreign domestic helpers in a way which rendered a referral to the NPC unnecessary. In July 2008, on his Hong Kong visit, Mr. Xi Jinping, at that time the Vice President of the People's Republic of China, urged the government, legislators, and judges to cooperate with one another for the maintenance of the stability and prosperity of Hong Kong. It is not known why he made such a statement, but it made Hong Kong people very worried. The Hong Kong Bar Association issued a strong statement which said this: "The judiciary in Hong Kong has always been, and under the Basic Law it shall remain, separate and independent from the executive and the legislature. It is not and should not be regarded as part of the governance team. Legality of government action is subject to judicial scrutiny. Unless the judiciary is truly independent, it cannot fulfill its role of ensuring that the government is acting in accordance with the law." These words had not been forgotten when 6 years later, in June 2014, Mr. Xi Jinping's early passage was repeated with much greater elaboration in a document called White Paper on the Practice of One Country, Two Systems Policy in Hong Kong Special Administrative Region, published by the State Council. Judges at different levels and other judicial personnel are regarded as part of the administration team, together with the government officials and legislators. As such, they have the responsibility of correctly understanding the basic law. They have the understanding and implementing the basic law, of safeguarding the country's sovereignty, security, and developmental interest. The problem is this. First of all, it says that the primary role of judges is to support the state. Secondly, it suggests that judges have a political responsibility to uphold the state's interests. This is completely alien to the concept of judicial independence and the rule of law as it is understood in Hong Kong and the West. Moreover, to emphasize patriotism as a political requirement for judges is just a step from disqualifying non-Chinese judges because they do not meet the patriotic requirement. Little will be left of the rule of law in Hong Kong if judges are expected to give patriotic judgments instead of deciding cases according to the law and only the law. Further, this means a candidate for judicial appointment or promotion can be disqualified on a political assessment of being unpatriotic. What is said in the White Paper is at variance with the language and spirit of the Basic Law, and certainly at variance with the practice of the courts in Hong Kong. If the White Paper represents the current thinking and true and future policy of China, then the threat to the rule of law cannot be underestimated. Even if the judiciary is prepared to stand firm, the effect of such strong directives may well have effect on the appointment of judges and the public's perception of how judges will try cases in the future. The rule of law, as we understand it, is far from unknown in China, but successive valiant attempts to foster it in China had ended with little sustained success. China's open economic policy had brought about another wave of development. Although the focus was on commercial and economic law, the growth of the legal profession in China meant that an expanded class of people wanted to see the rule of law in China. Trained in the law, lawyers in China defended the rights of individuals against public authorities at the risk of their own interest and safety. Support for judicial independence had come from the very top of the judiciary. I remember listening to a speech of Xiao Yang, then President of the Supreme Court of the People, in the Great Hall of the People in 2004, in which he pledged China's commitment to the development of an independent judiciary. The principles that he put forward were no different from what we are familiar with in Hong Kong. But in the Chinese language and in the context, the statement was 10 times more moving and brave. Consciously or unconsciously, Hong Kong has been playing a role, not only a conduit for foreign investment, but in the structuring of regulatory systems, inevitably the principles of the rule of law which underpin them. Hong Kong also provided rich intellectual stimuli. The great debate in Hong Kong over the NPC Standing Committee's power of interpretation triggered a similar debate amongst Chinese scholars. Indeed, it concerned them even more deeply. Chinese entities litigating in Hong Kong are learning about the rule of law from direct experience every day. In a word, the geographical proximity, the common Chinese language, the fact that Hong Kong is part of China, the frequent transactions between the two places make Hong Kong's influence and contribution, knowingly or unknowingly, more direct when China was minded to build its rule of law society. true to China's meandering history, open door or closed door policy, embracing universal values or insisting on Chinese characteristics, are an unceasing struggle with one another. In recent years, the emphasis by the state, the emphasis on the rule of law took a subtle change. Control by the state and stability at all costs had taken the upper hand. The emphasis on ruling the country according to law may sound familiar to the rule of, may sound similar to the rule of law, but is its very opposite. Put starkly, the rule of law means the party is under the law. Ruling according to law means the party uses the law as a tool to control the people while itself staying above the law. From our point of view, it is a regression. Had China strictly observed one country, two systems, Hong Kong may have been insulated from the effect, but it has not been so. Moreover, because the chief executive of the Hong Kong SAR was elected by an elite group largely controlled by China, Hong Kong is completely exposed. The present chief executive, elected in 2012, has taken to pursuing what he considers to be China's directives. In accordance with the white paper, Hong Kong's justice system should be pressed into the service of the government to control Hong Kong. The systematic subversion of the rule of law and substituting it with ruling by law is now in full-fledged. That matters to Hong Kong, of course, but that will soon erode our public institutions and make them unsafe for us and for anyone who trades with us. But at the same time, Hong Kong will cease to be a source of positive influence for the rule of law in China. If the rule of law matters for China, then the maintenance of the rule in Hong Kong matters to the world. The contents of the white paper had even wider implication for Hong Kong's democratization. In effect, the white paper rewrote the Basic Law from the very foundation of Hong Kong's autonomy in accordance with one country, two systems principle. Every conferment of autonomy in the Basic Law is now qualified by the need for China's involvement and fresh approval. The high degree of autonomy, says the white paper, is the power to run local affairs as authorized by the central leadership. The high degree of autonomy of the SAR is subject to the level of central leadership's authorization. This is a far cry from the Joint Declaration and the Basic Law. Under the Basic Law, the degree of autonomy is defined by law, not by the directives of the leadership. Once given, an authorization under the Basic Law cannot be curtailed without an amendment. Hong Kong people's rights under the Basic Law are guaranteed by law, not by the political sufferance of China's leadership for the time being. Hong Kong people have been exercising their rights and freedoms fearlessly. They commemorate the 4th of June every year with a candlelight vigil attended by tens of thousands. They march in the streets in large numbers to protest the imprisonment of Nobel laureate Liu Xiaobo. They march to protest the suspicious death of discharged Tiananmen prisoner Li Wangyang. But there is increasing concern about the political influence from Chinese officials dominating Hong Kong affairs through the SAR government. This gave greater urgency to the demand for democracy and for the right to elect the chief executive and all members of the Legislative Council. Hong Kong people have been fighting for democracy for decades, but time and again, real progress was put off by China and the SAR government. In 2013, as a last resort, a legal academic advocated a civil disobedience movement called Occupy Central, with the aim of putting pressure on the government by paralyzing the central business district. This inspired instant enthusiasm, but support for the action was mixed. In spite of this, the government pulled out all the stops to oppose the movement. But if the white paper was intended to quell all challenges to China's authority to decide on Hong Kong's affairs, it backfired. The white paper angered the people and roused them into action. As a result, 790,000 people cast their votes in a people's referendum organized by Occupy Central to send a clear and loud message to the Legislative Council to veto any government proposal for electing the chief executive, which is inconsistent with universal standards of universal suffrage. They voted in spite of the government's threats that the referendum was unlawful and against the Basic Law. The government retaliated in an anti-Occupy alliance, launched an extensive signature campaign and a march to oppose the movement, criticizing it as selfishly causing economic loss to Hong Kong. On 31st of August 2014, the NPC Standing Committee issued its decision on the election of the chief executive by one person, one vote in 2017 in accordance with Article 45 of the Basic Law. It was more uncompromising in its harshness than most people expected. 3 restrictions were imposed. 1, a nomination committee of 1,200 persons will pick all the candidates, and no more than 2 to 3 candidates will be chosen. 2, the nomination committee will be constituted in the same way as the election committee, which currently elects the chief executive. 3, to become a candidate, a person must have the endorsement of no less than 50% of the members of the nomination committee. This assures that China will have firm control over who is to be elected as a chief executive through the nomination committee. Not just only people acceptable to China will be allowed to enter the race. There may be no real race at all. No one, not even the SAR government officials who have to sell the package to Hong Kong people, can believe that this is real universal suffrage. So their sales pitch was rather pocket it first, and try to make it better next time. But China has never promised any further improvement or said that this is only an interim measure. On the contrary, Chinese officials emphasize that this is universal suffrage under the Basic Law. Universal suffrage, as defined by international conventions, have no relevance. The decision sparked off the umbrella movement. The umbrella movement is the single most important event in the history of Hong Kong as part of China, and will have great significance for Hong Kong, for China itself. Books will be written about the umbrella movement of 2014. For present purpose, it suffices to note that it is the accumulation of 3 decades of fighting for democracy against Britain and China, and marks a new departure for Hong Kong's democratic movement. The movement occurred by accident, continued by design, and was brought to an end with the intervention of the courts. The umbrella movement covered the period from 26 September 2014 with a sit-in protest of students and ended on 15th of December when the last Occupy site was cleared by the police. The whole Occupy period lasted 79 days. Over 1,000 people were arrested, detained, charged, or recorded for further investigation within that period. A poll by the Chinese University of Hong Kong showed that over 20% of the public participated at one time or another in the Occupy, which amounts to 1.2 million people, or 1/6 of Hong Kong's population. The Occupy movement occurred by accident. In the week of
22nd of December, a week-long class boycott was organized by the university students to protest the NPC decision outside the government headquarters and Legislative Council complex at Admiralty. They were peaceful and orderly. On the last day of the boycott, some students dashed into the closed government forecourt and were immediately arrested by the police. On the 27th of September, a protest rally was held at the site to support the students and demanded their release. The next day, as the students were not released, more and more flocked to join the rally. Police tried to block off access. The tens of thousands of protesters gathered finally broke the barrier and flooded into the carriageway separating them from the rally. In the late afternoon, after a brief warning, police fired tear gas into the crowd, who were armed only with eye goggles and umbrellas intended to ward off pepper sprays. 87 canisters of tear gas were fired. Signs were displayed which warned, "Disperse or we fire." This shocked the public and awoke memories of Tiananmen. More people rushed to the site to protect the students. Organizers at the original rally, who were all sitting down waiting to be arrested, called upon others to disperse and not to risk their lives. But people refused to leave. Then, abruptly, police action was called off. Many supporters who could not get to the site spontaneously set up occupied sites in Mongkok and in Causeway Bay. There began the long period of stalemate between protester and police. The police made no attempt to remove the protesters, and the protesters would not leave the sites. The Occupy continued by design. But by whose design? At various parts of the long period of the Occupy, many kept vigil at the sites and just slept on the ground. Some left during the day and returned in the evening. Volunteers put up barricades made of materials that they have scavenged from the streets nearby to block off the carriageway they occupied and to protect the occupiers. They were harassed by an anti-Occupy groups of people who were prepared to use violence on the protesters and to remove their barricades. There were many confrontations, especially in Mongkok, and frequent flare-ups of great tension and danger. It was not clear what role the police assumed. The government made frequent calls for protesters to disperse and threatened to use force to clear the sites, but the threats were not carried out. The protesters called upon the government to give in to their demands for genuine universal suffrage. They sought to resolve the situation by negotiating with the government, but it all came to nothing as the government made clear that the NPC decision, which was at the root of it, cannot be changed. As the stalemate stretched from days to weeks, protesters started to pitch tents at the occupied sites. The Admiralty site became a tent city. Within the city, a dreamlike kind of self-governing community grew up. A special quiet zone of study room was set up for students to do their homework. Creative artwork appeared everywhere, especially with the umbrella motif. Mobile democratic classrooms were organized for academics and public figures to give talks and hold discussions with the occupiers. Spontaneous teams of volunteers were found to take care of daily needs such as food, hygiene, and medical care. Donations of food, commodities, and other necessities flowed to the sites. The atmosphere in Admiralty was relatively calm. In Mongkok, there was constant fear of either police crackdown or attack on anti-Occupy groups or persons if occupiers were to relax their vigilance. But undoubtedly, at the end of in each of the sites, a new sense of Hong Kong's identity was being hatched in those 70-odd days. The interesting question was, why was the Occupy permitted to last so long? As time went on, protesters at the site thinned out. There were many opportunities when well-planned police action could easily clear the sites and arrest all the protesters without any resistance. So why did the police choose not to end it at all, but just played a cat and mouse game? One answer was that the government deliberately allowed the situation to worsen to let the weight of resentment of the public who were inconvenienced by the protesters grow to tipping point. In this, the government was largely successful. According to some opinion polls, people who opposed the continuation of the Occupy rose to some 80%. The Occupy part of the movement was brought to an end with the intervention of the courts by granting orders of injunction in civil actions brought by private parties. The Mongkok injunctions were unusual and in fact unprecedented. It was a well-established legal principle that public nuisance, such as obstructing the public highway, is the matter for the Attorney General or the Secretary for Justice to take action if he sees fit in the public interest. It is not a matter for civil claim by a private party unless his private right was infringed or he has suffered direct, special, substantial damage over and above the damage suffered by the general public. These private actions, however, were brought by small companies which charged light bus operators a monthly fee for managing their routes, and by two associations whose members owned or drove taxis. They claim that the protesters and their barricades obstructed the traffic and caused them loss and damage. The applications were made without the defendants being notified or heard, and without the court being told how should the orders be granted. They were to be carried out effectively and in an orderly manner, although it would involve moving thousands of people and massive barricades. However, the court granted the injunctions. The reasoning of the judges was that while the plaintiffs may be able to establish at the trial that they have suffered the kind of damage which would give them the right to sue, the defendants had undoubtedly broken the law and anyway had no right to obstruct the highway. A date was set for the parties to argue whether the temporary injunction should be continued, but meanwhile strong warnings were given that interim injunctions were orders of the court and must be obeyed, and anyone flouting the orders would be in contempt of court. It was emphasized that such conduct would undermine the rule of law. The protesters may well be fighting for a noble cause, but they were not entitled to do so at the expense of the rule of law. Thus was the fight for democracy posed as a violation of the rule of law. The protesters did not give up and go away without a fight. Meanwhile, sympathetic public figures made great efforts to prevent the anti-Occupy groups from taking the enforcement of the injunctions into their own hands. On the return days, counsel were instructed to represent some defendants to resist the continuation of the injunctions. I cannot say too much about this at present, as I was one of the counsel instructed. Suffice to say that the resistance failed. The plaintiff asked for an additional order to direct the police to assist the enforcement of the injunctions and to arrest anyone who obstructs for criminal contempt of court. This is yet another unusual feature of the case. The Secretary for Justice who appeared in court at the invitation of the plaintiffs, said that the government did not want to step into the action, but was prepared to comply if the court made an order for the police to give assistance. The protesters accused the government of using the court's authority as cover to clear the occupied sites. In the event, this was exactly what the police did on the 25th and 26th of November. The bailiffs who were there to oversee the execution of the orders had very little to do. Police routed the occupied sites within and beyond the court orders and used unnecessary force to arrest unresisting protesters and even reporters. Additionally, a total of 55 persons, including a 14-year-old boy, were arrested for suspected criminal contempt of court. How they will be dealt with in the High Court, again in unprecedented procedures, remain to be seen. Finally, the Admiralty site had to be tackled. Another injunction was granted to a transport company to restrain protesters from obstructing the removal of the barricades at the western and southern tips of the site. By then, everybody knew that the police was going to use the occasion to clear the site. The protesters wanted to make it clear for all to see that the police action was no part of the court's order. Accordingly, they took care to withdraw from the areas within the injunction and rallied at the core part of the site. Many notable figures who had pledged their support to the Occupy movement, including founding chairman of the Democratic Party Martin Lee and media owner Jimmy Lai, went to the site and sat down with the students and protesters to await arrest. The police was determined to show how civilized they were. According to the government, 7,000 police were deployed in the action. A total of 254 persons were arrested. No resistance was offered. The tents and all the paraphernalia of Occupy were bulldozed and cleared away. Traffic was restored to normal. A few days later, the Causeway Bay occupied site was cleared without resistance. The chief executive, Mr. C.Y. Leung, claimed credit for having dealt with the biggest civil disobedience action with resounding success. He characterized it as a triumph of the authority of the rule of law. Every year in January, the judiciary holds a solemn ceremony to mark the opening of the legal year. This year, the challenge to the rule of law in the umbrella movement was the theme of the speeches of the Chief Justice, the Secretary for Justice, and the Chairman of the Bar Association. Each had something to say about what the rule of law really meant. The Secretary emphasized obeying the law as the basic requirement and criticized the protesters deliberately breaking the law and flouting the court orders as undermining the rule of law. There can be no democracy, he said, without the rule of law. The chairman of the bar criticized the government for confusing the rule of law with ruling by law, endlessly repeating that this or that was done according to law, he said, was typical of a tyrannical government. He also attacked with equal vigor politicians for defending the civil disobedience action as if fighting for democracy put it above the law. The Chief Justice emphasized equality of arms in arguing a case before the courts and a meticulously reasoned judgment as the hallmarks of the rule of law. He defended the court's ruling as addressing legal rights regardless of political overtone. But the question remains, did the government use the courts to achieve its political purpose of silencing protest? Chief Executive C.Y. Leung did not deny having done so and boasted about his success. But supposing he did, was it in any way at all inconsistent with the rule of law? Does it not forcefully illustrate how President Xi Jinping's admonition of judges cooperating with the executive and the legislature for the prosperity and stability of Hong Kong can work? Have we not, in fact, moved into the era of implementing the basic law as interpreted by the White Paper? There were many questions raised on the other side as well. One dark aspect of the umbrella movement was the numerous incidents of police brutality used on protesters, the selective exercise of the power of arrest, detention, and prosecution to punish those who criticized the government and to shield the government's supporters. The abuse of executive power is plainly contrary to the rule of law. And yet, where is the remedy? Assuming judges are independent and impartial and decide cases only according to the law, does a person on the wrong side of the government have any chance of seeking justice in the courts under our justice system? The chief executive of the Hong Kong SAR retains all the vast gubernatorial powers of the colonial governor, subject to China's control. Among these powers is the important power of appointment. For example, he appoints the chairman of the committee responsible for university funding allocation, the chairman of the committee which advises on dropping or continuing a corruption investigation. He appoints members to the Judicial Officer's Recommendation Commission. Most of his powers are not reviewable by the courts. If Hong Kong people are denied the right to choose their chief executive, how can they make sure that he and his senior officials will be accountable to the people of Hong Kong and safeguard Hong Kong's interests? Francis Fukuyama was perhaps only pointing out the obvious when he said, "A high degree of state autonomy, free of any form of democratic accountability and unencumbered by a rule of law, is a very dangerous thing." He believes that this is China's present situation. To prevent Hong Kong from falling into the same situation must be worth fighting for, even if the odds are against us. It is a worthwhile cause, not only for Hong Kong people, especially the young people who are fighting for their future in their city, but a matter that concerns the world. The white paper also sparked off an inquiry by the Foreign Affairs Select Committee of England's House of Commons. China protested that Britain had no locus to look into Hong Kong, which is China's internal affairs. MPs who planned to visit Hong Kong were told that they would be refused entry. In the debate in the House of Commons last December, a member told the House that a Chinese diplomat told him that the joint declaration was void and no longer has effect after 1997. The answer was confirmed by an SAR Gov official. The joint declaration, he told Hong Kong's Legislative Council, had completed its historical mission after Britain returned Hong Kong to China. The 12-point basic policy on Hong Kong was not part of the bilateral treaty, but only China's unilateral declaration and not subject to international scrutiny. We have thus come full circle back to the starting point of the joint declaration, which China has now apparently repudiated. Where does this leave the inhabitants of Hong Kong? How does this serve China? And what does this mean for the international community? The umbrella movement provides a profusion of extremely thought-provoking leads to these questions, but the jury is still out. Ladies and gentlemen, I thank you for your great patience in hearing me out.
I have agreed to take questions. In fact, not just questions, but I would welcome any views, because what looks to a person in Hong Kong may be very different to people who are outside Hong Kong. So your views, your criticism are very welcome, and I will try my best to answer any questions you have.
Thank you very much for your thoughtful analysis of everything that's been happening in Hong Kong. I have to confess, listening to you is very depressing, and that's probably true for people living in Hong Kong also. In talking about the different meanings of the rule of law, do you think there's any legal body that could say something in support of your position or local Hong Kong understandings of the rule of law that would have any influence within China?
Thank you very much. I'm sorry if it sounds depressing, but as a Hong Kong person, I'm so used to depressing news that every more depressing news actually make me feel more determined to do something about it. And I'm very glad to say that the youngsters who were out there in the Umbrella Square, they look at the difficulties and they look at the failure that had been imposed on them. And they're not downhearted. All they say is that things are not looking good now. But if we stay around and if we continue to do something about our own future and continue to take responsibility for our own lives, then who knows, maybe times will change and we will have a good chance of achieving what we really want to see. And to me, that is the motivation for me to come at this point, because Hong Kong has never been so black. And yet never have I seen so much hope, because a new generation is different from my generation. My generation is prepared to voice our views and put the responsibility on the governments to carry out, to do what is just. We go to the governments and tell them, this is what is just, do it. But the youngsters said, if you don't do it, we're going to do something about it. So depressing, yes, but I think it also gives us great hope because we have a brand new generation. There is a generational change in Hong Kong's politics. Mark the umbrella movement. This is a new start. It's not just another one. It's not just a mass. I have shown you many pictures of people marching in the streets, people sitting down in the park. This time is different. As to the rule of law, as I understand it, this is the general understanding of the rule of law in the whole of the legal profession. In fact, you would say that it is blasé. Nobody thinks that there is anything very special about it. And we more or less received the shock. Many of people of my profession only now realize that there are people who do not distinguish between the rule of law and the rule by law. Now, your question is, can we do something to influence China so that it understands our version of the rule of law, which is your version of the rule of law, and generally what we understand by the rule of law? And I think that we must not assume that people in China do not understand this. As I was saying a little earlier in my speech, in fact, a lot of intellectuals in China do understand this. Xiaoyang himself understood and promoted it. It is not new in China. It is the political situation in China which made it some people, the leadership perhaps, feel that that is not it's not safe to adopt the rule of law because it means that the party submits to control by the law, and somehow they feel that it will affect their sense of security. And they have to overcome this. How they're going to overcome this, I have no idea. All I'm saying is, why don't you let us continue to have our own rule of law in Hong Kong until you are ready? Then you are welcome to have the same thing. But meanwhile, let us keep our own. So I hope that answers your question.
Hong Kong has become such a business center in the financial industry and whatnot. And I'm just wondering what has been the reaction, if anything, of the business community, which, in order to be successful and breed confidence, needs dependable, independent laws.
Yes. The business community, like any other community in Hong Kong, for example, the professional community, the grassroots and so on, have different views. But there is a sizable portion of the business world who thinks that the short-term interest is not to rock the boat, not to get on the wrong side of China, because things are going well for them. Now, I personally have no problem with people fighting for their own interests. But I think that for the longer term of Hong Kong's interests, they must see that the rule of law is essential, is vital. There are people who say Hong Kong is no longer needed as a financial center because Shanghai is going to go past you. But is that real? Because with any finance business, any kind of service industry even, without the rule of law, you have no protection. If Hong Kong loses the rule of law, I doubt if you want to do business in Hong Kong. You know, you can ride on the present system and you can say, don't rock the boat. But the boat does not stay still. The boat may want to stay still. But if the political waters change, you will overturn. So that is why, because a lot of a business community has short-term interests, they don't want to trouble this kind of thing. And it is a difficult fight, you know, it's not easy. So, but the longer-term people see that keeping our regulatory system, keeping the government clean. How do you keep the government clean? Government has to internalize the rule of law. All these things are essential for Hong Kong. And in fact, it is because of this basis of our financial system that China is able to learn from Hong Kong. Now, we don't boast that we have anything to teach China, but we are there. And it is not the first time that China had learned from Hong Kong. And so I think that we will only realize that we have lost something without being able to retrieve it if we give up now. So the business community, in fact, would be the first people to feel it.
I wonder if you can talk a little bit more about people with different class backgrounds, their reactions to the movement. Are there any people who are against the movement? And also, like, I would imagine small shop owners and workers and probably foreign domestic workers, their reactions will be quite different from those, business people and also students. Thank you.
Yes, you are right that there are split views about umbrella movement. One figure I quoted to you, towards the end, 80% were against the people the students continue to occupy. But you must not confuse that with 80% of the people against the students or against their fight for democracy. They only think that you really should get out of there. You should not continue to occupy those places and obstruct because it's not helping you. There may be well-wishers, there may be people who are frustrated. So there are split views. And in fact, families are split on are you for or against Occupy? And I understand that so many people have been unfriended on their websites that it is quite unprecedented. But it is not a class thing. It's not the workers. In fact, if you go and walk down the Occupy, you find that it's not even an age group. Although the students are the motivating force and they're in the forefront because they're fighting for their lives, there are lots of people of all age groups who are there to support them. And among these people, there are poor people, there are middle-class people. Regularly, if because Occupy site is very near my office, so every now and then I would take a walk there, say when we finished work, and there'd be very expensive pastry being donated by people to students who are working hard. So it is not a class thing. And I don't think that there is any split view about the fight for democracy. Where it is split is the means of achieving it. Many people feel that Occupy is not the right way to do this. Many people feel that it is not the right way to do it because they don't think you will succeed. Some people feel that you shouldn't continue to do it because you should not fight for democracy at the expense of creating a traffic jam and inconvenience other people. So there are split views about ways of achieving it. Now, as to small shopkeepers, in fact, many small shopkeepers are the staunchest supporters of Occupy. They would come with loads of with bottled water for the students. They would come up with all sorts of things, with desserts for evening. You know, I told you about this study room for the students. When it gets cold, people come with warm drinks, with hot syrup, you know, for them to shield from the cold. When there was a call for tents, lots of people come. So it is not a class thing. In fact, it is very funny that even triads are split. So in Mongkok, the situation is very violent, or can be very violent. So some of the people who are doing violence are triads. But these triads are met with the defenders of occupiers, who are also, you know, somewhat with a background in the similar kind of class. So it is, I think that to sum up, you can say that it's very controversial. The controversy is in the means adopted, not in the purpose that they're trying to achieve. And the controversy of adopting this means is really a worry as to whether this would backfire. And their worry is not false. There were some good reasons for them, although I think that it was the length of the time, and whether the students were to be blamed is a different question. I personally don't think that it is entirely for the students, not to blame them. But, you know, after the umbrella movement, the question is now, how do you reconcile with the society? How do you find a new way forward? We've tried everything. We've even tried Occupy. Now, we're still not there. What are we going to do next? That's a very interesting question. You are right that views are split. But one thing is even more certain, and that is now you are left with very few people who don't have a view. Very few people say, maybe, maybe not, I don't know. What is the umbrella movement? Say that again. You don't have anything like that. Awareness is the first step.
So thank you so much for that very eloquent talk. And what you just ended with was my question. So what next? Hong Kong can't unfriend China. You know, it's there. And you're dealing with, as you say, a very complex political situation now. You're a longtime activist in many different roles. Here you've got the students energized. I mean, do you see that there are some mechanisms going forward? I mean, even in your role as a barrister, to try and argue against these procedural irregularities that you talked about, et cetera, et cetera. And what about the students? What do you see as the next, some positive steps forward that you can take to start engaging Hong Kong government, Beijing government, to pressure these new awarenesses?
Thank you for an extremely good question. I was hoping that someone would ask this so that I can boast about this, not about myself, but about the students. You know, they are taking it in a much more calm way after they've got over the first wave of deep disappointment and a deep sense of failure. You know, so now they're trying to sum up, where have we gone wrong? Why have we not got enough community support? Have we alienated some people? What do we do next? And I think that, first of all, they are all, most of them, I mean, of course, there were some people who are less active, but the most active of them are keen to go on. They are keen to find ways of bringing community awareness. They realize, you see, what motivated them in the very core is that this is my home, this is my life. If I don't do anything about it, nobody is going to do anything about it. I have a right to do this. I have a right to be heard. So in other words, it's taking possession of the public arena. So what they are now doing is that they go to each community, the districts, the different levels, the different classes, the shopkeepers, the business people, to talk to them, to get them to be interested in their own problems and solve them. Not always just, we must fight for democracy, we must fight for the rule of law, but what about the public open space in your area? You're most concerned about the price of property. Now, what can we do about it? Going there, understanding what is the real problem, practical problem that people are facing, and try to find a way to get people together to solve that kind of problem because they own the place that they live in, one way or another. That is very encouraging. Also, many of them immediately said that they are interested in participating in politics. They want to stand for election. When I talked to them and I said, look, this is a generational change overnight. The present pan-democrats are have-beens, they are out of date. They're on the way out. It is for the young people because their views are completely different. They don't shy away from it. Although they are very critical of people in LegCo now, they don't give up LegCo altogether. Although district councils are, very local things, they are interested. And I've been talking to them and I said, how are you going to do it? And they have clear ideas that they must bring something new. They're critical of political parties. So they are trying to fight because political parties have lost the trust of a lot of people. So, but they realize that being completely free and spontaneous is not going to achieve the goal. So where do they find the middle, the kind of organization which is bottom up, which would bring people together, which would help different views to come together, have a debate and reach some kind of decision that they would all stand by? All this sort of thing. And they are trying to now organize themselves in this way and map out what is their strategy if they are going to run for an election. And it wouldn't depend on their being elected. It depends on their joining in the election. So in every way, on every level, they are looking for plans, they're looking for organization, they're looking for connecting, they're looking for engaging. And they do not feel any qualms about talking to the mainland officials if they have an opening, or already now they are pestering the Hong Kong government, look, talk to us, you've got to talk to us. What's the point of running your consultation paper if you don't intend to listen to our opinion? So I don't know if that answers your question, because many things are in being, they are being done. But it is precisely because so many things are happening that you are very hopeful. This is a generation who is not going away and who is determined to be engaged and to engage other people in the dialogue. They deserve a lot of support. Even elderly people must try to.
I had a question about your question. You said you raised one question: why was it allowed to go on for so long?
Yeah.
And you only addressed one possibility. And I wondered if you were going to address other possibilities.
I asked the question because I cannot make a statement. You see, looking at the Occupy part of the movement, the umbrella movement is still going on. That's why I use my language like that. The Occupy part is over because the sites are cleared. Now, I very much wonder what was the original tactic of the government. It seems clear to me that the original tactic was to use force to clear the site following in the days immediately following the 28th of September when all these tear gas were released on the crowd. Because the hospitals, now first of all, if you look at the pictures, the police were carrying guns. They are equipped to shoot plastic bullets. Hospitals were alerted that there may be many wounded, as many as 500. The hospitals were prepared, ambulances were prepared, and so before police action was called off, I think there was clearly something that the government was planning on suppressing it. The question for many days, especially, we thought that the 1st of October or immediately before the 1st of October, the celebration, or immediately after the National Day celebration, government is going to use force. The PLA would be called in, and there was a very, very tense discussion about whether the PLA would be called in, and there are people who say you first have to announce a curfew before you can engage a military. And you remember there were a few days when the vice chancellors of the universities, even the former chief justice, the cardinal were really tearing their hairs out, going to tell the student, go home, do not risk your life. So I think that was something real. So the plan was changed. So what was the plan B? I don't think that they had a plan B. I think they were caught, the action was called off. And then they tried to figure out what to do. And maybe there is a situation of the students not being able to leave because the students didn't know how to leave. You know, with retreat is a very, very difficult art. You know, if you give them, if they can announce some kind of achievement, that may be an excuse for them to leave. But if they have achieved nothing, then they will find it impossible to tell people that they are leaving. Now, the government could easily have given them some achievement, but it purposely held off. Many times when the students started to build bridges to have a discussion, suddenly the government would say something to make this impossible. So looking at the thing with hindsight, you know, with the opinion rising against the Occupy, people in the Occupy sites, then I get an idea that this was what C.Y. Leung had been waiting for, you know, so that when he, and using the tactics of the court orders, we believe that these plaintiffs were not, there were a few, but not all of them, were there spontaneously. So all this shows that someone has been engineering something. But I think that if C.Y. Leung thinks that it was a success because when it prolonged itself, then students get onto the nerve of the general public. The general public was no longer lost patience with them. But these 79 days were also very, very unique in making people stay together. They suddenly have a community. They will never be able to forget the umbrella movement, that they were a member of this village. You know, so I think they are certainly, I think probably, you know, you are a sociologist, you know that many things don't happen by any particular person's design. And anybody, if they have a design, the design may not work out. But a lot of accidents, a lot of semi-successful designs, a lot of semi-failures, somehow one way or another, make the Occupy much longer than it was first intended. When Benny Tai designed Occupy Central, he thought that it was going to be a day and a half. It didn't think, nobody imagined that it was going to be 79 days.
Thank you, Margaret, for that very compelling and impassioned narrative. I may be asking one of the last questions in the audience. And if I could just take you from this activist scene and throw out a more academic question. You know, the 21st century, the first decade and a half is we've seen unprecedented scale and scope of occupation movements. And in many ways, I wonder how do students see themselves? Do they see themselves as part of this more global moment? And then we don't even need to talk that big, just that, you know, from the perspective of China, Hong Kong and Taiwan have a lot in common. And they definitely keep a very close eye on both of them. So I'm just wondering, even this idea of reaching out for a broader regional alliance or support, because so much of what you've talked about today is very much the local eye. And it seems like it's largely, the impact is largely locally contained. But I'm wondering of the repercussions regionally, right, for the umbrella movement. I wonder if you could say a word or two about that.
It's a very interesting observation you had, because I think it is the internet age which make it very easy and almost inevitable for us to copy from one another. You know, if you look at Benny Tai's original idea of the Occupy Central, he was trying to take, without doubt, he had taken some inspiration from Wall Street, from Singapore, you know, the Occupy movement in America, in England, in then it was picked up the world over. But it wasn't exactly the same thing. His civil disobedience is very different from the kind of civil obedience that you were talking about in Gandhi or Thoreau, and I debated with him and said, I find this slightly mixed and so on. And also the Hong Kong Occupy movement, of course, had sort of copied from any of these, and also what happened in Taiwan, occupying the legislative chamber, gave the youngsters a lot of inspiration. So all the time you are copying from one another, and I am sure that we are copying things from the mainland less than the mainland people are copying from us, and so we copy from each other, but what we copy from each other is only very superficial, because the deep issues are local. And I think that is, if you like, a reaction against globalization, which has been making people feel that they are losing control of their lives. And so the movement there is, the real thing is, let's get back down to earth. What concerns us, and do we have any more control of our own lives? So I think all these are very interesting studies. There are so many topics. I think it would give, already there's enough for about 100 PhD theses. So if each one of the young people sitting there want to write a PhD, there'll be lots of material, That's fine, that's fine. I'm very pleased.
Thank you. I had a very quick question about the shadow of Tiananmen on Occupy Central, especially with regards to police involvement. You say that people were very supportive generally, but not necessarily of the method of protest. And I wondered if there were any indications of police disobeying orders, if there were orders.
Yeah, right. Tiananmen, certainly the shadow of Tiananmen was very large, because what triggered off the Occupy was actually the tear gas, and also the disperse, or we should. Now, they explain that was a mistake. He said, you're just looking at the wrong side of the banner. The right side is, please go away, because we would release tear gas. It's just that to save another banner, we have it at the back, and you looked at the back instead of the front. But I think it is the moment you can see this force being charged on the crowd, then a lot of Hong Kong people, I show you that picture of the candlelight vigil. You can see, whatever the spectrum you stand on in democracy, in fighting for democracy, Hong Kong people are of the same view when it comes to Tiananmen, because the stamp is too strong for them to forget. So the moment you have the police, the anti-riot police, in the streets firing tear gas, then Tiananmen immediately sparked in everybody's view. And that is why they rushed to the site. Instead of running away, they rushed there. They rushed there to protect the students. Tiananmen must not happen in Hong Kong. I think that was also at the back of why the police action was stopped. Someone higher than C.Y. Leung did not want the image, even a lesser version of the image of Tiananmen, to happen in Hong Kong. And so the police, very funny, the police again is split. You have the police who were really brutal. You see this image on the videos, in YouTube and so on, really using the police batons to beat people from above, beating people on heads, on their backs, when people are retreating from the site, when they are dispersing. That is unforgivable, is inexcusable. So you have police officers who are like that, and you can see their face, the violence in their face. And then there are police who are very worried about this kind of brutality. You see some of the net media, the online media, you have articles written by these police officers who said, I am ashamed of my colleagues who are doing this. We had the police, the Hong Kong police, had such a good reputation in the community. We had such overwhelming trust from the community, and you are destroying this. So the police was split. At one point, it threatened mutiny. And that is why a lot of things were happening behind our backs. You know, we will not be able to find out until many years later from the archives exactly what happened in the police.
Thank you for being here today to share your point of view. In your lecture earlier, you mentioned that the Hong Kong government officials have been socializing pretty hard in terms of the election agenda that is being set by the Beijing government. And in your opinion, do you think the people of Hong Kong are going to settle and just pocket whatever that is being put on the table right now?
Right now, I think that it is very unlikely. But if you see, the interesting thing is this. In 2004, the NPC Standing Committee, having changed the procedure for introducing political reform in Hong Kong, actually created a very interesting situation whereby the Standing Committee will issue a decision about what Hong Kong should do, which Hong Kong's Legislative Council can veto. Don't you think that is amazing? You know, and so now it depends. They don't have the pro-government lobby does not have 2/3 majority, and it was in the Basic Law that they require 2/3 majorities to pass, because at the time in 1990, when the Basic Law was promulgated, they thought that the trend will be there will be overwhelming demand for democracy in Hong Kong. And so as to make sure that it will not be passed just by majority, they made it 2/3. But now they do not have the 2/3 majority in LegCo, so they will have to get some of the Pan-Democrats to go over and vote with the government. They need 4 extra votes. But now, this time round, I think it's much more difficult for them to get the 4 votes. Now, of course, never say never. You never know what's going to happen nearer the time. But I think that it would be a very silly risk to take, because if you look at the demographics, you find that the latest poll that I looked at before I came was that 43% of the general public polled said you should not pocket it. 35% or 33-point-something% said pocket it. So if you compare the 2 percentages, the people say that not to pocket it would still be more, but neither of them reach really a clear majority. You know, any large change, a fundamental change, should not pass by a bare majority. 60-40 will not do, but the government is doing this all the time, but now you don't have 60-40. Now, the interesting thing is, at the same survey, if you look at the age group of 18 to 29, the percentage of rejecting it is 74%. So if you force it through LegCo, what happens is that your younger generation would rebel. So what will happen come 2017? So I think that it is not working. So don't worry about it. If it doesn't get through this time, we back to square one, still have the election committee, we'll have a way of dealing with this. But if for any reason it got through, then what? Then it's another scenario. I think much depends on what your aim is and whether you are able to look at reality and see how in the real situation you are going to fight for the best for Hong Kong. But I don't think that this proposal, this NPC decision, should be accepted. I think it is very bad for Hong Kong, and it's going to be very bad for China. It will make Hong Kong ungovernable.
Hello, thank you. I'm sorry for the voice. At some point in your answers, you mentioned the fact that CY Long could have given away something to the students, and that he decided not to. But my question was, what do you think he could have given away? Like, to what extent has he been a complete puppet in this story? Or
I think he is more than a puppet. He actually is quite enthusiastic. He believes that all the colonial institutions are bad and should be abolished, including universities, including the rule of law, and so on and so forth. He's a very strange person. Not strange, but strange if you look at a Hong Kong person. Now, when you have a very strong party, the government, who has all the powers and all the influence, and you have a very weak party, namely the students, and you have a negotiation, always the weak had very little to give, and the only strength it has is to dig its heels in. There is a lot that the stronger party can give. For example, it can be more conciliatory. It can say, let's continue the negotiation, let's continue to talk, and let's do this, that, or the other, and find a way forward. But they were not interested. In fact, it was quite the opposite. Whenever they are about to, you see, there were talks before the talks, rather like the joint declaration. How are we going to talk? You know, so you have talks about how they're going to talk. You know, and so they say, well, there has to be more than one round, it has to be a neutral ground, and so on and so forth. When they are almost reaching consensus, then something happens, and it has to be called off. Yeah. That didn't, I haven't quite got you, right?
yeah, no, you answered part of my question, but another part of the question was, I mean, to what extent the students were talking with the people that actually mattered? That was my question, because it was a strange situation. You had this negotiation in Hong Kong with very Hong Kongese local problems, and Beijing was in the background, and it was obviously the most important, protagonist in the story on the government side. So that was my question: was what autonomy do you think Hong Kong authorities had to negotiate with the students, or did he have Beijing on the phone every day telling him, what to do, basically, because they're calling the shots in the bottom line is this one.
We believe that during the umbrella movement, he was receiving practically, this chief executive was practically receiving daily instructions. But on a day-to-day basis, does he receive day-to-day instructions? Does the China liaison office on this term is much more active and much more participatory and so on. So it may be that. But I think the way we look at it, a normal Hong Kong person looking at it is this, that especially for someone like me, being trained in the law, we look at legitimacy. Here's the basic law who says that your chief executive is supposed to represent Hong Kong. So as a Hong Kong person, you run after him, whether you like him or not. This is the proper thing for you to do. And you do that is legitimate. Now, so the students look for, first of all, they wanted to talk to the chief executive, and they call for his resignation, which doesn't help. You can't call for someone's resignation and at the same time ask to negotiate with that very person. So they realized that they got the logic wrong. So they said, we don't want to talk to him anymore. We just want to talk to the chief secretary, who is the head of the civil service, so to speak. It is when they have hit a blank wall that the students then wrote a letter to the central government. And they say, well, it seems that this government, we have difficulty talking to the government who ought to be representing us. So can we come and talk to you instead? Which I think was very proper. And reading that letter in Chinese, I think that was a very polite and very, very decent kind of Chinese. It's the kind of letter that you would be very proud of. So I will no longer say that our students don't know Chinese. So in the future, what do? Do you talk to people who matter? Yes. But I would say that they recognize one thing, even one more thing, and that is before you talk to anyone, before you ask, who are you? Do I talk to you? You have to ask yourself, who am I? Who are the people behind me? If I have the community behind me, then that's one thing. If I only have a group of students behind me. That's quite another. You know, if you're going to negotiate with someone who is strong, stubborn, insensitive, and so on and so forth, all these impolite words, then you make sure you are very well equipped. And I think the students have gone away to get better equipped. That is a one-line answer to your question earlier.
Thank you. I have a quick question. How serious do you think the problem is that umbrella leaders may be targeted, not only by the Hong Kong government, but by the authorities in China, targeted personally in order to silence any future activity?
I think this is very, very worrying because of the nature of the tactics. It is a way of spreading a kind of terror that if you are involved, you will be marked, and your private correspondence, particularly your emails, your online communication, will be looked into under the pretext of criminal investigation, or worse, prevention of crime, because criminal investigation requires a crime which you are investigating. Prevention of crime does not require even that. So if you have your private life looked into, you know, you don't have to actually be thrown into prison. So I think that lots of people are feeling the oppression. And now, of course, this thing is spreading. Not only, I mean, I said that 254 people were arrested in the square only on that day, but more than 1,000 people have been arrested. And even more than 1,000 people arrested. You see, before they took action to start arresting people in Admiralty, they say, we're going to do it at 3 o'clock. Now, those of you who don't want to be arrested, please go now. And everybody who left the site had their ID card, their identity card number copied, their particulars copied. They're going to be followed. So they use this as a kind of intimidation tactics. And I dislike this because this tactic is not so much that these people are going to be under surveillance, but it is a tactic which tells you, I am placing you under surveillance. And this is a tactic which is very alien to Hong Kong. If we want to do secret surveillance, we used to do it really secretly. You know. But it is when you try to threaten and intimidate, you use this kind of tactic. Now, you look at what is happening in the university now. The law faculty, now the whole world knows, the law faculty is under attack from the chief executive in his position, he says, as the chancellor of the university. The most respected law professor who is likely to be recommended for promotion to be a pro-vice chancellor is under attack. And what is his crime? His crime is that his department harbored Benny Tai, who suggested Occupy Central, harboring someone the government dislikes. Now, the latest explanation of C.Y. Leung was that I am not interfering with the university, but as a chief executive, I have a duty to protect national security. So he is raising that to the level of national security. Now, if you charge anyone with a crime, say any crime against national security, you have to name the crime. You have to name the act. You have to bring the evidence. You have to name the mental element before you can go to court. But if you just attack someone for the sake of protecting national security, you don't have to give any particulars. And you can start investigating a lot of people. You can start asking questions in such a way as to intimidate. And I don't like this. This is not Hong Kong. This is not the way Hong Kong operates. So that I'm glad to hear that a lot of academics are now protesting. They are writing petitions to say, we can't have this. If you start to do this interfering with the universities, we're not going to survive as a decent university. The university, law faculty of University of Hong Kong is number 18 on the world list. You know, who will come to your law school to teach if that is how they are going to be treated? So I'm glad that people are protesting and saying, and drawing the line. They are going to draw a line. This is what beyond this, we will not accept. But what you are saying is the thing which worries us most at the moment. Thank you all. Thank you. Thank you very much. Thank you.